Good morning. We are from New Miller and Beardsley, and we're here today to present on working through a pandemic. This is employer guidance for COVID-19. My name is Lisa Blanco Jimenez. I'm an attorney at New Miller and Beardsley and chair of our employment law group. With me today are two colleagues at New Miller and Beardsley, Ricardo Aranda. Say hi.
Hi, good morning.
And my colleague, Roberto Jimenez.
Good morning.
Okay, so let's get started. We are going to cover a lot of material today. I do want to let you know that this presentation is not intended as a substitute for legal advice by an attorney that you retain and provide specific information to. Today is meant to be an overview of things that you should be concerned of as an employer in light of the COVID-19 pandemic. We are not going to cover things that already existed prior to COVID-19 or the specifics of the laws that have always been in existence. Rather, we're going to focus on things that you should be aware of that are new, different, or of particular concern because of the COVID-19 pandemic. So we will get started with some material regarding the Federal Families First Coronavirus Relief Act presented by Ricardo Aranda.
Great. Go to the next slide. Thank you. So one of the first pieces of legislation that was implemented due to the COVID-19 pandemic was the Families First Coronavirus Response Act, and I'll be referring to it either as the FFCRA or just the Act. And that was implemented way back in March, and it became effective April 1st, and it will expire at the end of the year unless it's extended. And so far, I haven't heard anything about whether it would be extended. The FFCRA provides paid sick leave for reasons related to COVID-19 and an expansion of the Family and Medical Leave Act, FMLA. All right. So the slide we have now, hopefully this poster or one like it looks very familiar because it's required to be posted. Employers are required to post it for its employees. It explains the basic rights provided by the FFCRA. And I'll just quickly go over the basics because hopefully you've seen these before. The Act provides 2 weeks, it's 80 hours for full-time or an equivalent part-time, however many hours a part-time person works, the employee works in 2 weeks. 2 weeks of sick leaves for specified reasons, such as being ordered or advised to quarantine, or if an employee is experiencing symptoms and seeking a diagnosis, or needing to care for someone or their child because of COVID-19. Now, the sick leave expires with the Act and it does not carry over, and unused balances do not have to be paid out at termination. And for the expansion of the FMLA leave, that is another up to 12 weeks of paid leave for an employee who needs to care for a child whose school or place of care has closed or is unavailable due to COVID-19. Now that also expires at the end of the year. So if an employee hasn't used it by now, they wouldn't get 12 weeks because by my calculation, there's only 11 weeks left in 2020. Again, the Act applies to employers with 500 or fewer employees. And for the expanded FMLA leave, employees must have been employed for at least 30 days. But that's not the case for sick leave. As long as an employer has 500 or fewer employees, effective April 1st, all the employees should have been granted 2 weeks of sick leave. Go on to the next slide. And that's the Spanish version of the poster that was highly recommended to post. Employers are recommended to post in any language that they know that the workforce would understand better. Next slide, please. So some things to be aware of regarding the FFCRA and California law. So the sick leave under the FFCRA is in addition to the paid sick leave required under California law. And actually, it's any sick leave that the employer already provides. So if employers were thinking that they already provided 2 weeks of paid time off, they had to provide additional 2 weeks of federal leave. And recently, under California law, California passed AB 1867, which provides supplemental paid sick leave to fill in some of the gaps in the FFCRA. So that the supplemental leave applies to employers with 500 or more employees, so those who are excluded by the Act, and providing 80 hours of sick leave when the worker has to self-quarantine or isolate themselves, or has, for health reasons, cannot work due to COVID-19. And then also under the the supplemental bill, where employers could exclude healthcare workers or emergency responders, the new California law now provides the supplemental leave to any employees who were previously excluded under those provisions. So next slide. So those are the California law plays into the FFCRA. So what I want to focus on, those were the basics of the FFCRA, the basic, rights and leave amounts provided under the law. So what I want to talk about for the rest of this section is what I refer to as the frequently asked questions. And those are interpreting the provisions of the Act as provided by the United States Department of Labor. I think if you click on if we transition to there should be a link to the website. There it is at the bottom of the website that has the frequently asked questions. And I find myself, checking it frequently. Last time I saw it had about 103 questions and responses. And so these are the ones I find myself being asked, quite often. And if you see here, a lot of them refer to the definitions under the Act. So the Act provides for leave paid leave at the employee's regular rate. And so that's an average over the 6-month period and is not limited to just their hourly rate. It could include, if applicable, it includes commissions or piece rates or other forms of compensation that the employee usually receives. Another definition that has been that has come up in the question a lot has been the phrase that the leave has to be because the employee is unable to work because of a COVID-19 reason. Now, this was confusing because in the beginning, the state issued stay-at-home orders and non-essential businesses had to close, and so everyone figured that that's a reason for taking sick leave. However, the Department of Labor's opinion was that that did not apply where the employer did not have any work for the employee to perform. The reason that the businesses are closed and have no work is because customers weren't able to go into the business. And so in that sense, that it's not the employee who's being unable to work, it's the business itself. So that was a very confusing part, made even more confusing by a court ruling in New York, federal court, which back in August struck that ruling requirement that the employee be unable to work. However, recently the Department of Labor went back and reevaluated its regulations and still affirmed that yes, in order for an employee to take sick leave or expanded FMLA, they must be unable to work because of one of the COVID-19 reasons, and there has to be work available to the employee. And another definition that's been changed recently is that the healthcare providers could be excluded under the FFCRA, and that originally was a broad definition that could possibly include anyone who worked at a healthcare facility, but has been since narrowed to those employees who are actually providing treatment or testing, not rather than just any other employees. And so, and again, as far as the other definitions regarding the FFCRA, when leave is taken to care for a son or daughter, that means any biological adopted stepchild or anyone under 18, or an older child or over 18 who is incapable of taking care of themselves due to a disability. And when the FFCRA talks about a child's place of care or school being closed, that can refer to not just school, but to daycare or a home if that's the child's usual place of care. That is, the parent has to take time off of work because there's no childcare for their employee. And a child care provider can be anyone, anyone who cares for the child. You can be paid, such as a nanny or babysitter who can no longer come into the house because of COVID-19, or an unpaid position, a family member or friend who regularly comes by to care for the child. You can go on to the next slide. Right. So, and then recently, with the schools moving to distance learning, there's been a lot of questions regarding what does it mean to have a school being closed or unavailable for purposes of the FFCRA. And the Department of Labor has clarified that the leave is only available when the employee is actually needing to care for the child and is unable to work or to telework. So it's not available if someone else is able to care for the child, such as a co-parent or some other child care provider who's available. The employer can allow the employee to take intermittent leave so the employee can work a partial day. And the Department of Labor does encourage employers to be flexible with these arrangements so that if they're working partially, they don't have to use as much as the leave as required. We can move on to the next slide. So for a school or childcare to be closed, I'm sorry, can we go back to the previous slide? Sorry, great. So for a school or childcare place to be closed, that means that the physical location is closed. So it could include distance learning, but that's only where that is the only option, or if it's part of a hybrid in-person or distance learning option where the school would be closed to the students on those days where they have to do distance learning. Now, some of the more recent responses from the Department of Labor clarify that so the leave is not available when schools are reopening and the parent or the parent chooses to either homeschool or continue with distance learning. Even where the school provides distance learning as an option, if the school is also open, then the Department of Labor has said that FFCRA leave would not be available in that instance. The school has to be closed. The next slide, please. Great. So other frequently asked questions regarding when the employee has to be subject to an isolation order. Again, I've talked about when the state shelter-in-place orders actually applied, work must otherwise be available. But it also, in order to isolate from a government agency, also includes guidance where a specific group of persons, such as older employees or employees who have medical conditions that make them susceptible to COVID-19, have been advised to also stay home and not work. For self-quarantine, it must be at the designation of a healthcare provider, and the employee must also be seeking a diagnosis. The employee cannot just feel sick and then take leave without also having to seek a diagnosis. Now, the employers can condition the employee's return on a negative COVID-19 test in the cases where there's been a known exposure to COVID-19. We can go on to the next slide. So for sick leave to care for someone else who is quarantined, again, so the employee themselves is not experiencing symptoms or been advised that they're caring for someone, that person that they're caring for must be genuinely unable to care for themselves, and someone who needs the employee's care, such as a family member, someone in their household, or some other relationship that creates an expectation that that person, the employee, would normally take care of them in this instance. And again, because the possible exposure, the employer can condition the employee's return from leave on providing a negative test. real quickly on one, I think I missed the slide, but I wanted to talk about taking leave intermittently. Now, not as a, not all at once. Maybe the employee thinks they can, take leave for, only a couple of weeks and then, or maybe 1 or 2 days on a shortened schedule. Now, the intermittent leave can only be provided if the employer agrees, and the employee may not work intermittently at the work site. They can work telework unless the reason is related to having to care for a child. Now, for the other reasons, the other reasons that they involve to some extent the employee possibly being exposed to COVID-19. So the rationale there being that these employees should avoid the workplace, until their leave is exhausted or until, there's no longer a risk. So intermittent leave is available in limited circumstances, and always the employer has to agree. If the employer does not agree, the employee just takes the leave until it's exhausted or they don't need it anymore. And so finally, I think on the right there, that the last slide I have is the process for requesting leave and providing documentation under the Act. Now, the employee must provide certain information and documentation, such as the employee's name, the dates they're requesting leave, a reason for the leave, one of the 6 reasons listed on the poster, and a statement that they are unable to work because of that reason. Now, depending on the reason, the employee may be asked to provide, the name of the entity that issued the isolation order, the name of the healthcare provider who's told them to self-quarantine, the name of the school that's unavailable. But otherwise, the Department of Labor has said, the requirements to provide doctor's notes or other, excessive documentation should be limited due to the burden it would provide on healthcare facilities. And they've also said that this information does not necessarily have to be provided before they go on leave. It can be provided in a reasonable time afterwards. Now, that was a very condensed version of the FFCRA and some of the questions that have arisen. If you have any questions, please feel free to submit them, and we'll try and get to them at the end of the Q&A session. And for that, I will move on to the next.
Thank you, Ricardo. Okay, so please do submit your questions. This area of the law is fraught with confusion for employers. You can submit your questions now and throughout the presentation. We encourage you to do that as they arise, and we will pick them up at the end of the presentation. So do submit your questions as we go along. So moving on to wage and hour pitfalls. So anyone who has employees in the state of California knows that there are a lot of rules about how long employees can work, when they may be entitled to overtime and the like. So I want to touch on just 3 areas, next slide please, that you should be particularly concerned about in light of the COVID-19 pandemic. And so the first area is classification issues. Classification referring to whether you treat the employee as exempt from overtime laws or non-exempt. Exempt employees are what we call salaried exempt, and non-exempt are hourly employees. The second issue of concern has to do with timekeeping, and the third area has to do with reimbursement of business-related expenses. So I will start with the first section regarding classification issues in light of the COVID-19 pandemic. Okay, so the first question you should be asking yourself when it comes to your salaried exempt employees is, have their duties changed in light of the changes that you've had to make to the workplace and to your business as a result of the COVID-19 pandemic? And I will give you some examples of where that may occur. So the first example we have here in this scenario is a manager who has been classified as exempt under the executive exemption before the pandemic. And now this manager no longer regularly directs the work of at least 2 employees in the workplace due to a COVID-related reduction in force. So here we have a situation where the executive exemption had applied before COVID, And one of the elements of the executive exemption applying, otherwise known as the managerial exemption, is that the exempt employee must regularly direct or supervise the work of at least 2 employees. So if that manager no longer has at least 2 employees under their supervision because of layoffs in your workplace, then you're going to have to reconsider and reevaluate whether that person can continue to be classified as an exempt. And if they, in fact, have lost the exemption because of this change in circumstances, you'll have to transition them to being an hourly employee, subject to overtime, subject to rest breaks, subject to meal period requirements, and the like. All right, moving on. The other question, another scenario that may arise regarding duties changing is an example of a human resources specialist. This is somebody who had been classified before the pandemic as an exempt employee, probably under the administrative exemption. But now this human resource specialist spends his or her time also answering phones at the front desk because the receptionist perhaps had been furloughed. So now this person, if they spend more than half their time answering phones, they are no longer primarily engaged in the functions of a human resources specialist that are exempt functions. And you're going to, again, have to transition this employee to an hourly non-exempt status. Next slide. So in both, the second question we should need to ask ourselves is, has pay changed? So if pay has changed, we also have a situation where we'll have to reevaluate the classification of the employee. And I'll give you an example of this as well. So in this scenario, we have a finance manager who had been classified as exempt before the pandemic, again, probably under the administrative exemption. And now this finance manager is working part-time on a remote basis at half the salary previously earned. And so here we have reduced the finance manager's salary in light of the reduction in the hours needed to perform the job given changed circumstances. So if they're making half the salary, the new salary is $48,000 a year. Previously, the finance manager had been earning $96,000 a year. And the complication caused by the reduction in salary, even though it's a prorated reduction, is that we are now below the minimum salary threshold required to maintain any of these exemptions under California law. The minimum salary that you must pay an employee in order to treat them as exempt is 2 times the minimum wage for full-time employment. So you take your minimum wage, it could be $12 an hour. It's at different rates depending on the size of your employee base, and you multiply that by 2,080 hours, which is full-time employment for a year, 40 hours a week times 52 weeks a year, and that minimum salary is what is required to maintain the classification of exempt. And so 48,000 falls below that threshold, meaning the person now has to be transitioned to an hourly non-exempt status. And finally, another scenario of where pay changes can create issues is here we have an executive assistant who had been classified as an exempt before the pandemic, and this executive assistant is furloughed on Fridays for the next 3 months. And on those days, she's required to use her accrued paid time off. Now, here in this situation, you're actually okay to continue to maintain the exempt status of the executive assistant. And that's because the executive assistant is continuing to be paid on the furlough days. The furlough is a minimum time. It's only 3 months. It's only 1 day a week. And she has enough paid time off in her vacation bank so that she can continue to be paid. So again, her salary is maintained. There's no reduction in her salary because she's getting paid through the use of her accrued paid time off. Therefore, you do not have to transition this employee to non-exempt status. So again, these questions, they should be prompted in your workplace to the extent that you have had duties change with your exempt workforce or pay changes with your exempt workforce. Each scenario is going to be very fact specific. So definitely seek counsel if you have any confusion about that. Next slide, please. The next subject I want to talk about very briefly is timekeeping concerns. Next transition, please. So remote work environments are particular landmines for potential wage and hour violations. You have serious supervision issues you have to deal with. You have employees who are self-reporting when they're coming in and working, as opposed to clocking in on a time clock at the workplace, etc. So we definitely want to make sure that we're paying special attention to timekeeping with employees. Next transition. So we have situations where we need to ask ourselves, are employees starting work earlier than they normally would? Are they working later into the night or into the evening? Are they working on the weekends? Next transition. Are they logging in to complete small tasks on their days off because they have access to the workplace in their own home? They may be working after hours outside their normal schedule. And if they're doing this and you're aware of it or should be aware of it, then you need to be paying for this time worked. Now, one way to deal with this with employees who you don't want working after hours is to reinforce your rules about that. And if employees continue to work when they're not supposed to, you should impose disciplinary action against those employees. If not, then you're condoning the work, and you're certainly benefiting from it if it's for the benefit of your business, in which case it should be paid. The other question you need to ask is, are employees taking their lunch breaks and their rest breaks? Just because they're working from home doesn't mean they're not entitled to breaks, and you should be making an effort to enforce those rules as well. Rest breaks are paid, so they're not clocking out, but they need to be disengaging from the work environment and taking a break for themselves. Lunch breaks are a clock out situation, and you want to make sure they're getting non-exempt employees are getting at least 30 minutes before they complete the 5th hour of work. So you want to make sure that their breaks are timely and that you're controlling that. And again, reinforcing it by disciplining when necessary. So the final issue I want to talk about very quickly is another area that's really ripe for concern here in this environment, and that's reimbursement of business-related expenses. So remote work environments, again, are landmines for expense reimbursement claims, and there are a number of kinds of expenses that you should be mindful of and appropriately reimbursed for, and that includes such things as Wi-Fi, if your employees are having to log in from their home computers and access their Wi-Fi networks, their cell phone use, postage, if they're now having to mail things from their home as opposed to using your office supplies, other office supplies or equipment that they may be having to use that's personally owned by them. And then if they're doing business-related errands that would normally be handled differently if they were in the workplace, you want to make sure that they're appropriately compensated for the mileage associated with the personal use of their own vehicles. So definitely make sure that you are considering these things, finding fair and reasonable amounts to compensate employees, reimburse them for these personal expenses. And this is a very careful area for employers because an expense reimbursement claim, if it leads to a lawsuit, has what's called an attorney's fee provision, which means you'll not only have to end up reimbursing the employee for the use of their personal equipment and data, etc., you'll also have to pay for their attorney's fees and having to litigate the issue. So be aware, be careful, and make the right decisions in this regard. Okay, moving on to the next section, Roberto Jimenez is going to talk to us about concerns related to discrimination and accommodation claims.
Good morning. Next slide, please. So I'm going to talk mainly about two laws, one federal, one California, the Americans with Disabilities Act and the Fair Employment and Housing Act, both of which make it unlawful for an employer to discriminate against an employee because of a protected category, such as disability or age. And under both the ADA and the FEHA, an employer has an affirmative duty to provide reasonable accommodations for the disability of an employee if the employer knows of the disability, unless the employer can demonstrate after engaging in the interactive process that the accommodation imposes an undue hardship. Now, when an employer can may request reasonable medical documents, and this is a concern during the COVID-19 pandemic. But given the difficulties an employee may have with obtaining these medical documents from their doctors, the Department of Fair Employment and Housing does recommend that employers waive these requirements before an employer provides a reasonable accommodation to an employee. Now, there are some employees that are higher risk for severe illness from COVID-19. So if the underlying medical condition qualifies as a disability, then the employer should really think about making a reasonable accommodation absent some undue hardship. Another concern is older employees. According to the CDC, older adults are at higher risk. However, because age is not considered a disability, employers aren't required to provide reasonable accommodations based solely on their age. But employers must remember that age is within a protected category and should not discriminate against employees, older employees. Now, there's a question as to whether an illness related to COVID-19 is itself considered a disability. And according to the Department of Fair Employment and Housing, it depends. It really just depends on the severity of the illness. Next slide, please. Okay, so some other concerns with the anti-discrimination laws are the use of PPE. In other words, personal protective equipment. Now, employers may require that employees wear PPE during the COVID-19 pandemic, such as face coverings, masks, gowns, and things of that nature. If an employee with however, an employer has to consider that if an employee with a disability needs a related reasonable accommodation, then the employer should really consider granting that to them absent some undue hardship. For example, there are some employees who may require the use of a wheelchair, and if the employer provides, or if the employer requires that the employees wear gowns as PPE to kind of help stop the spread of COVID-19, then the employer should obtain or provide gowns designed for those who use wheelchairs. Now, there's some potential liability for violating the anti-discrimination laws, such as the employer may have to pay the lost wages of the affected employee, damages for pain and suffering, and other punitive damages that may be really significant. Next slide.
All right. So now we have Ricardo speaking with us regarding workplace safety issues, OSHA concerns.
Great, thank you. An employer's duty to provide, OSHA mandates certain workplace safety requirements, and an employer's duty to provide a safe work environment includes making the environment safe from COVID-19. Now, Cal OSHA has provided on its website, several downloadable guides for safety practices based on specific industries. Now, I haven't reviewed them all, but generally the ones that I've been asked about, it seems that all of these safety practices for COVID-19 focus on specific categories, and that includes having a written plan and providing actual training on screening employees for symptoms, taking temperatures of employees before they come into the work site, and asking them if they've had the symptoms of COVID-19, such as sore throat, shortness of breath, and other symptoms. The other category for the plan includes maintaining physical distancing within the work site, and that can be moving workspaces 6 feet away, and adjusting entrances and exits to the facility so that people aren't passing each other in the doorways. And the final category usually involves having a plan in place and training to provide a method for sanitizing the work site. And the specific details based on industry are available at the Cal OSHA website. Now, there's been another recent law, that's AB 685, provides enhanced penalties and allows Cal OSHA to shut down work sites when there's been for failing to follow guidelines and creating a hazard related to COVID-19. And some of the citations I've read about being issued involve an employer's failure to provide PPE, protective equipment, failing to implement screening procedures, and not providing training, and also failing to report COVID-19 illnesses, including those resulting in death. In addition to the reporting requirements, is that employers must immediately, within 1 business day of a potential exposure, notice of a potential exposure, provide written notification to all employees at the worksite of the potential exposure, the COVID-19 benefits, such as the FFCRA, and what disinfection and safety measures that the employer will take in response to the exposure. And that's more information can be found at the websites down below at the end of the slide.
Thank you, Ricardo. Return to you, Roberto, with a discussion regarding whistleblower retaliation claims.
I'm going to talk a little bit about whistleblower protection and wrongful termination. So as an example, a whistleblower can be someone who reports his or her employer to the authorities for the employer violating some law or failing to adhere to some regulation or guideline. For example, the OSHA requirements, industry requirements just discussed by my colleague Ricardo. And an employer, employees in California who report their employers for apparent health and safety conditions safety violations related to COVID-19 may be protected under the whistleblower protection laws. And acting out against an employee who reports the employer can be considered retaliation. And retaliation can refer to any adverse employment action taken against an employee for reporting a dangerous working condition. An adverse employment action can be like termination, wage reduction, change of schedule, and other like things. Now, there's another concern when the employee is discharged for these reasons, because an employee cannot be discharged for reasons that violate a fundamental principle of public policy, meaning that if the employer fires an employee who is exercising their rights under the whistleblower protection laws, then that employee may have been wrongfully terminated. Now, if the employee is wrongfully terminated and brings suit against the employer could be responsible for lost wages, benefits of the employee, punitive damages, and other things. Next slide. Okay, now I'm going to talk a little bit more about mass layoffs and the WARN Act. Now, the WARN Act protects employees, their families, and communities by requiring the employer give a 60-day notice to affected employees and both state and local representatives prior to a plant closing or a mass layoff. Now, there is good news for the 60-day notice requirements under Executive Order N31220. The state temporarily suspends the 60-day notice requirement in the WARN Act on the condition that the employer do the following. First, the employer must give written notice to affected employees, the EDD, the local workforce development board, and the chief elected official for the county in which the WARN Act activity is being taken place. And the employer must also give as much notice as practicable and must provide in that notice a brief statement of the basis for reducing the notification period. And the employer must order such a mass layoff, relocation, or termination that is caused by COVID-19 related business circumstances that were not reasonably foreseeable as of the time of the notice. And lastly, the notice must contain the following statement, which is, if you have lost your job or been laid off temporarily, you may be eligible for unemployment insurance, UI, More information on UI and other resources available for workers is available at labor.ca.gov/coronavirus 2019. Next slide, please. Now, employers must really note that this executive order does not suspend the WARN Act in its entirety. It only suspends the 60-day notice requirement. And it lasts for the period that began on March 4th, 2020 through the end of the state emergency declared as a result of the threat of COVID-19. Now, there are some possibilities for civil penalties of $500 per day if the employer fails to provide this notice. And they may also be responsible for back pay and other costs to the employee. Next slide, please.
Thank you, Roberto. So I will talk briefly about changes to workers' compensation laws as a result of the pandemic. So the first change that came about was Governor Newsom's Executive Order N6220, which provided that all California employees who worked at the direction of their employer at a job site outside their home between March 19th, 2020 and July 5th, 2020, and who tested positive for COVID-19 within 14 days of having worked at the job site during that period are presumed to have contracted the illness at work for purposes of workers' compensation benefits. So this means that unless you can establish evidence that the employee contracted the illness outside of the workplace, the presumption is that it's a workers' comp covered claim. Slide, please. Following the executive order, more recently, the governor signed a bill, SB 1159, which extends this same rebuttable presumption to the current time, so after July 5th, 2020, but only for two categories of employees. So the presumption was extended for first responders and healthcare workers. And secondly, employees who test positive for COVID-19 at any employer site during an outbreak at their specific workplace. So what is an outbreak? An outbreak exists if within 14 days, any of the following occurs. 1, 4 employees test positive if the employer has 100 or less employees. 2, 4% of the employees who reported to that workplace test positive if you have more than 100 employees. Or 3, your workplace is ordered shut down by the state, including OSHA, or any local public health department or a school superintendent. So if you have, if you meet the definition of an outbreak at your workplace, again, the presumption that it's a covered workers' comp claim will apply. I also want to point out that beginning on January 1st of the upcoming year, you will need to comply with a number of exhaustive notice requirements if you have a confirmed exposure or outbreak in the workplace. So definitely be aware of all of the notices expected of you as an employer in the context of COVID-19 as the new year approaches. My best advice to you is that if you have a situation where an employee of yours has been diagnosed with COVID-19, that you call your workers' comp carrier and get a claim started. Even if presumption doesn't apply, at least you've got something going there so that it can be handled appropriately. Okay, next I'll have us, Roberto, speak about COBRA changes. Roberto, you might be on mute. We're not hearing you.
Sorry about that. So as you may know, COBRA requires a continuation coverage be offered to qualified individuals when an employee's job ends or their hours are cut. And generally, when an employee's hours are cut or terminated, the employer has to notify the group plan administrator within 30 days. And after within 14 days of that notification, then the plan administrator has to notify the employee and their covered individual, their qualified individuals for continuation of coverage. And then generally the employee has 60 days to sign up for the continued coverage. Now, in light of the COVID-19 crisis, the Internal Revenue Service, the IRS, and the Department of Labor have granted temporary relief to employees who failed to meet the just discussed deadlines during the outbreak period. Now, the outbreak period began March 1st of 2020 and will end 60 days after the announced end of the COVID-19 national emergency. So in other words, under the current rule, the 60-day time frame doesn't start until the end of the outbreak period, which as of right now is unclear when that will be. Now, for there are, as you can see on the slide here, there are potential penalties of $110 per day for failure to provide this notice to the employee. There may also be a responsibility on the employer's part to pay for costs of incurred medical expenses by a qualified beneficiary. And if there is a lawsuit, then the employer may also be responsible for paying the employee's attorney's fees and costs. Next slide. Thank you.
Okay, great. So now is an opportunity for us to address your questions. If you submitted any questions during the presentation, we can answer those now. If you haven't, you can proceed to do so. So the first question we have is, will the presentation be available to view outside of the convention? I believe that convention presentations are being recorded. I can have someone on staff confirm that. If it's not being recorded and being able to be reviewed by you, I can certainly have the slides distributed to people via email if there's a request for that information. And you can do that through the California Hispanic Chambers of Commerce. Make that request and we'll be sure to accommodate you. You can also email one of us. The slide that's up on the screen now has our email addresses, mine, then Ricardo's, then Roberto's. They're on the screen. Our first initial and last name at
Well, I think she's going to say our emails are first initial last name at newmiller.com. I also believe that the presentations are available on the website for 90 days. Any other questions?
Next question. As a small business, I don't always have access to legal counsel. Are there resources available to help simplify the information? I want to ensure we're correctly implementing resources for employees. So depending on your question, there are a number of resources available. For example, if you have a wage and hour question, overtime, that kind of thing, the resource available to you would be the Department of Labor Standards Enforcement, DLSE. It's a California state agency. It's also known as the Labor Commissioner's Office. There's an office in Stockton, there's an office in Sacramento, and throughout California. And you may be able to get some guidance by calling, but they also have a website and also a document called an enforcement manual, which answers a lot of questions that employers may have about the law. If you have a question regarding unemployment issues, there's a really good website that the EDD has regarding unemployment in the context of COVID-19. If you have a question regarding the Families First Coronavirus Response Act that Ricardo spoke about at the beginning of the presentation, you can go to the United States Department of Labor's website. He threw that address up earlier. And have perhaps one of the frequently asked questions, maybe your question, and then the answer will be clearly stated there. And there's also a telephone hotline as well available with the DOL. But I understand that it's very hard for small employers to navigate all of these issues. But I will tell you from experience, having both counseled employers and then litigated claims that have resulted, when there wasn't counsel, that, you know, prevention can really save you a lot of headache and money. So if you do have a little bit in your budget to seek employment counsel when you have a sticky situation, it could certainly save you a lot of heartache in possibly avoiding litigation or a claim against your company. All right, Ricardo, we have a question about the FFCRA. Do you want to take that one?
Right. So the question is, are employees required to provide the name of the child and the child's schools to get the enhanced leave? And yes, that is part of the basic information that you would provide: the name of the child, your child, and the name of the school that's been closed. If so, does the follow-up is, if so, does the employer have the right to contact the school to verify? I would think, you know, they would, but also, you know, there's not a lot of, you know, again, the Department of Labor has been very adamant that, you know, as long as the employee provides the information, that shouldn't jeopardize the leave. But of course, you know, the employer may, you know, if they would, there's nothing that prevents them from contacting the school to find out. But you know, but so in that case, I would say yes, you know, it's possible, but usually these, you know, school closures are, you know, pretty much, you know, matter of, you know, not public record. They're in the news or otherwise. But yes, you know, that's the information you have to provide under the FFCRA.
All right, any other questions? We have about 5 minutes left. Another FFCRA question for Ricardo.
All right, so is the employer only required to post the notice at the work site? Right, yes. So that is a good question. I think that is also on the frequently asked questions, that the employers should also, you know, it doesn't do a lot of good to post at the work site if everyone's working from home. So yes, a copy of the poster should be provided electronically or you know, to those employees who are working from, you know, not going into the office. And the poster I showed you is available at the Department of Labor website, and it is downloadable, so you can send it as a PDF.
Okay, so we have a question following up on one of the scenarios I presented regarding exemption issues. And the question is, what happens if the executive assistant does not have enough PTO to cover furlough days? And that's a great follow-up question that kind of puts us into the scenario 3 question, which is if you're going to deduct pay because now they're only working 4 days a week as opposed to 5, if the deduction or reduction of the salary reduces the salary to less than 2 times minimum wage, then yes, you would lose the exemption. But if you're still maintaining the minimum salary component, you can hold on to the exemption. So you're still going to have to do that math and make sure you're hitting that minimum salary requirement, which is 2 times minimum wage for full-time employment. Right, we have an accommodation question. Do you want to tackle this one, Roberto?
So what if the employee resides their primary residence with someone who is covered under the ADA? And can they request an accommodation? So do you mean the person who is not the employee, can they request an accommodation?
Yeah, I think what they're asking is there an accommodation obligation for someone who is disabled other than the employee? And short answer is no. The ADA doesn't cover family members. There may be other laws that come into play, FMLA being an example, including possibly the extended FMLA or sick leave that Ricardo discussed. But the short answer is the ADA covers accommodations for your employees who are disabled, not family members of employees who are disabled.
Same thing with the Fair Employment and Housing Act.
Yeah, the most likely scenario there is definitely going to be an FMLA type request if it applies. All right, we have a couple minutes here. Any other questions before we wrap up?
Who or how can employees report issues?
I'm not seeing any other questions. I don't know if one sees
There's
it.
one about, the question is, who can the employees report issues? And it looks like it's a workplace safety issue. The question is about someone who, knowing an employee who was infected and resulted in death, and that, presumably the employer didn't report it. If the employees can contact Cal OSHA. I believe there is either a hotline or an email address on the website that you can submit complaints to, and that, I think that's through the Department of Industrial Relations. Again, on my slide regarding workplace safety, there are links to the Cal OSHA section of the website.
Yes, and again, there are going to be significant increased obligations for employers to report outbreaks or confirmed cases of COVID-19 in the workplace starting January 1st. It's going to be kind of another complicated area to be aware of. I also wanted to follow up on something Roberto said about whistleblower retaliation, and whistleblower protections attach even when the employee reports a health and safety violation internally to someone in the workplace. So you could not fire someone for reporting a safety violation internally or externally, as was mentioned. So just something to be aware of about making sure that you're not retaliating against people for exercising their rights to make a report internally or externally. Okay, so again, our email addresses are up on the screen. If you'd like a copy of the presentation, you can reach out to one of us, or you can reach out to California Hispanic Chambers of Commerce, and we will be sure to follow up. We are at the end of our hour here, so we are going to close down questions and answers, but please send an email if you have some follow-up questions. We can at least attempt to point you in the right direction, and reach out if you want a copy of our slides. Thanks so much for your time with us today. It was a pleasure for us to provide this information to you. We want you to be smart and educated employers, and we're here as a resource to assist you in accomplishing that. Thank you.
Thank you.
Thank you.